Thank you, Mr. Chair and members, and thank you, Mr. Chair, specifically for allowing us to go out of order due to accommodate my witnesses from Washington, D.C. or back east and from Southern California. I want to address the members of the body for just a second and tell you that in my presentation you'll hear the word abortion, but please don't close your ears on either side of the issue which you find yourself on, because it really has not a lot to do with that particular issue. It has the context of a violation of separation of powers. So I'm proud here today to present a bill to stop illegal actions and abuse of power by officials within the Department of Managed Healthcare. The executive branch is responsible to execute and enforce the laws passed by this legislative body. It does not make laws, nor does it change the laws, or nor is it permitted to selectively enforce the laws that they don't like. But with blatant disregard for the separation of separation of powers, the Department of Managed Healthcare officials assume the role of legislators by reinterpreting clearly understood state statute to mean something different than it has meant for the last 40 years. This illegal action in and of itself should be bad enough. But on top of this, the Department of Managed Healthcare's officials change in the law in such a way that it has violated the religious liberties of thousands of churches and other California employers at the same time it has violated federal law, and putting in jeopardy tens of millions of dollars in federal health care funds that this state needs to balance its budget. This all started last summer when the California Department of Managed Healthcare suddenly changed its policy and threatened to punish any insurance company who sold healthcare policies without elective abortion coverage. It did this in spite of the fact that nothing in California law nor the Constitution requires private health plans to cover abortions, and despite the fact that the federal Weldon Amendment forbids this type of discrimination. The Department of Managed Healthcare Director Michelle Rouillard justified her actions by interpreting a meaning of the application under the 1974 Knox-Keene Act in the California Constitution. Why does Ms. Rouillard think that she has the authority to decide what a 40-year-old law means and changing that law that was the intent of the legislative body at that time? This is a blatant abuse of power that the members of this legislative committee should not tolerate, even if you agree with Ms. Rouillard's policy. This decision also violated the Hyde-Weldon Conscious Protection Amendment, which prohibits states like California from discriminating against health insurance companies offering plans that don't provide abortion coverage. The Department of Managed Healthcare has clearly violated this law and now have put into jeopardy over $40 billion in federal funds for programs under the Labor, Health, and Human Services Education Appropriations Act. The Hyde-Weldon Conscious Protection Amendment is based on a well-established and cherished principle that no one should be forced to participate in abortions against their will. This principle established a tentative peace between those who support abortion rights and those who, like myself, consider abortion a great moral evil. The Department of Managed Healthcare has completely disrupted this established principle and left every church, every private school, every nonprofit, and every business with no choice but to buy abortion healthcare coverage for its employees. It's an unconscionable assault on the most fundamental freedoms that we enjoy in this country. Ironically, California exempts certain religious employers from allowing them to not include contraceptive coverage in their health care plans, but the exemption does not extend to abortions. 7 California churches, with the help of Life Legal Defense Foundation and Alliance Defending Freedom, have filed a complaint with the U.S. Department of Health and Human Services offices for civil rights over this illegal discrimination and violation of the law. LLDF and ADF have also filed a complaint on behalf of 7 Loyola Marymount University employees who were forced into a plan covering elective abortion under the DMHC's order. My Bill 1254 will simply restore the status quo that has been in place for 40 years and ensure that the Department of Managed Healthcare follows federal law by prohibiting it from discriminating against healthcare companies selling insurance policies without abortion coverage. This bill no way prohibits insurance companies from providing abortion coverage. It just removes the abortion coverage requirement and brings California back in compliance with federal law. Witnesses here to testify are Alliance Defending Freedom Senior Counsel Casey Mattox and Senior Pastor of Calvary Chapel, Chino Hills, Jack Hibbs. You're on.
Mr. Chairman, members of the committee, thank you for this opportunity to speak with you. My name is Casey Mattox. I'm Senior Counsel with Alliance Defending Freedom. On August 22nd, the Department of Managed Healthcare ordered all insurance plans offered in the state to cover all legal abortions. The result is that my clients, California churches and other religious employers, were immediately compelled by the state to provide coverage of and pay for elective, even late-term abortions, and individual employees were forced into those plans. This discrimination against health plans that do not cover abortion violates federal law and jeopardizes a significant part of California's federal funding. Assembly Bill 1254 would simply restore the status quo. I will not belabor the point that DMHC's new interpretation of the 4 decades old Knox-Keene Act was not required or even supported by California law, because even if it were true, and DMHC was just now, for the first time in 40 years, in compliance with the law, federal law would still prevail. California accepts federal taxpayer funds under the Labor, Health and Human Services and Education Appropriations Act. For a decade, California has agreed in accepting those funds that it will not discriminate against a health insurance plan because that plan does not cover abortion. Forbidding licensure of these plans, excluding them from the state of California, is discrimination. The DMHC did not discuss the Weldon Amendment in its order and has never explained how its order complies with this federal law. The bill analysis, which you all received, also does not mention the Weldon Amendment. I find that quite surprising and shocking that the bill analysis you have does not even attempt to explain how this DMHC order complies with the Weldon Amendment. It also does not address either the First Amendment or the California constitutional protections for free exercise of religion, even though DMHC is literally forcing my clients, California churches, to pay for abortions from tithe money. This is illegal and unconscionable. These are churches spending their resources to meet the needs of their communities by feeding the hungry, assisting women in crisis pregnancies, running sports programs for at-risk youth, and even allowing local government to use their buildings for free. They're being repaid by their state government with an illegal and senseless order to pay for abortions for church staff. The HHS Office of Civil Rights is investigating the DMHC. HHS has the authority to terminate tens of billions of dollars in federal taxpayer funds to California because of this violation of federal law. This is not an idle scuffle in the cultural war. Federal taxpayers have made a bargain with California. It is now in violation of that agreement because of the illegal actions of one state agency. This Assembly has previously rejected this extreme position from DMHC by exempting some religious employers from the contraceptive mandate. The Assembly understood that forcing churches to pay for insurance coverage that violates their conscience is wrong. The DMHC has not approached elective abortion with such care and has gone around the legislature in order to enact this new rule. On behalf of my clients, I ask that you support this bill.
Go ahead.
I'd like to speak from the heart to all of you regarding my personal experience as a pastor. I'd first of all like to preface what I'm about to say in light of the fact that on December 24th, 1957, I survived an abortion, so I'm very happy to be in front of you today right now. As a pastor, I represent not only the thousands of pastors in California, but the millions of Christians in this great state regarding our belief and our convictions in the Bible and in God and in natural law. And being a pastor, I am daily called upon to counsel and to give comfort and to guide people through the greatest decisions of their lives. And that guidance and that comfort does not come from any man or myself, but from God and from the Bible. And exercising that freedom that has been afforded to me, both under the Constitution of the United States and by Almighty God, I live my life upon the convictions of my religious commitment to my faith and to my God. And from the beginning of this nation and the Americans' founding, it shows that the pastors of America were the clarion voice and the founding fathers in their decisions that they made. And like them, we must be unwavering pillars called to stand for what is right in the eyes of God. And as a pastor, we are to uphold and honor that which honors God and that which honors life. And so I call upon my brothers in the pulpits of California to stand for life. Yes. It is vitally important. And to ask you to side with us, to demand that our convictions and that our obedience to God be recognized, as is our religious and American freedom allows us to be. I demand that those convictions not be disobeyed and not be rejected, but based upon my religious convictions, I must adhere to what I understand the Bible to say. And when I'm asked to fund abortions, to take tithes and offerings from people who come and worship in our church and segregate some of that money out for elective abortions is against our faith, it is against the Bible, and it's against the very God of life. And so we cannot comply with a ruling or an attempt by this state to even go against God, but also against the Supreme Court of the United States that has already ruled regarding the Hobby Lobby case regarding our conscience. And so I'm encouraging you to please consider this. A church has the freedom to answer to God rather than man. And we are concerned citizens. The church that I pastor, over 10,000 people, over 8,600 of them are registered voters. They're engaged. They love their state. But this is a very serious issue that challenges our religious convictions. And I'm being asked by the state that I love, and I was born in San Diego, here my state is asking me to violate my faith and to do something that is against our God and against our Bible. And we cannot do that. Thank you.
Thank you. Further witnesses in support, name and organization and position only, please.
In support, Gina Gleason, Executive Director of Faith and Public Policy.
Karen England, Capital Resource Institute, in support of religious freedom and AB 1254.
Tim Lefevre, Pacific Justice Institute, in support.
Danielle Cullum, City on the Hill, in support.
Kristen Morrow with the California Catholic Conference, in support.
Brian Johnston with the National Right to Life Committee and the California Pro-Life Council. We urge your support.
Jonathan Keller with the California Family Council and California Family Alliance, in strong support.
Lynette Sills, urging a yes vote on this bill. Thank you.
I'm Ralph Merletti, member, St. Rose Parish, South Sacramento, and I strongly support this bill.
Patrick Lee, Roman Catholic priest, strongly in support of the bill.
Donald Chatfield, Fair Oaks, support.
Jean Crucero, Granite Bay, House to Home Showcase, in support.
Steve Patton, Catholic Diocese of Sacramento, urge your support of this bill.
Patricia Del Marmo, I'm the Northern California Area Director for Concerned Women for America. We are the largest women's organization with over 500 members nationally and 20,000 local in California. I strongly support this bill. Thank you.
Jacqueline Aguilar, Fair Oaks, California, in support.
Democrats, dare to oppose Planned Parenthood, at least on this, and vote yes.
Okay. See no other witnesses in support. Witnesses in opposition. Two witnesses up to 3 minutes each.
Good afternoon. My name is Margaret Russell. I'm a professor of constitutional law at Santa Clara University in Santa Clara, California. Thank you for the opportunity to speak in opposition to AB 1254. And in connection with that, I would like to say that my own university, Santa Clara University, was personally very much affected by the events involving the DMHC, and that we are a university community with many people who have strongly held opinions and faith. They have the freedom of speech to express their views, but not the right to violate California law, so that each covered employee is entitled to make her own decision about her pregnancy. Ensuring that health care plans provide coverage for abortion does not require any individual to use that coverage. It simply ensures that women have adequate health insurance. California law does not require employers that object to abortion to purchase a health insurance and policy that covers abortion, nor does it require health insurance plans that object similarly as well. In terms of constitutional law, this bill relies on a faulty interpretation of California constitutional and statutory law. California law states that insurance providers coverage for the full range of reproductive health care services, including abortion. These are basic health services to ensure that every woman with health care coverage can make her own best decision for herself and her family, not in accordance with her boss. Article 1, Section 1 of the California Constitution ensures each woman's privacy right in determining whether or not to carry a pregnancy to term. This long-settled authority is reinforced by California's Reproductive Privacy Act, which provides that a state may not deny or interfere with a woman's right to choose or obtain an abortion prior to the viability of the fetus or when the abortion is necessary to protect the life or health of the woman. This is in the Health and Safety Code. It is the law. The California Supreme Court further held in the Myers case, cited above, that California could not exclude coverage of abortions defined as not medically necessary while subsidizing all prenatal and delivery expenses under the Medi-Cal program. The court held that this would constitute unequal treatment in a woman's individual right to make critical decisions regarding her pregnancy. Under California's Knox-Keene Act, any legal abortion meets the Act's medical necessity criteria because the procedure is a clinically qualifying healthcare service provided by a physician to treat pregnancy. This is also in the Health and Safety Code. And finally, I would just like to say, in returning to my own employer, a university that was deeply affected, that there are many people who support the DMHC's right to continue to deny, suspend, or revoke the license of health plans if those plans exclude coverage for abortion.
Thank you.
Thank you.
Members, Christina Romero, Planned Parenthood, Affiliates of California, in strong opposition of AB 1295. We represent over 115 health centers across the state, serving approximately 1.5 million patients a year. In California, every woman has a constitutional right to decide whether to end a pregnancy. California has had a long history of supporting reproductive health access, including abortion. Some of these laws date back to 1975. Both the California Constitution and the Reproductive Privacy Act require the government to treat abortion and childbirth equally. California laws regulating insurance require that plans not discriminate against abortion by limiting coverage. In August 2012, DMHC sent letters to 7 health plans reiterating California law that says abortion, like prenatal care and delivery, is considered basic health care that must be covered in insurance policies sold to employers. The enforcement letters were sent after the agency learned that an insurance company had sold health coverage policies to 2 religiously affiliated universities that eliminated elective abortion coverage. Regardless of how one personally feels about abortion, I think we can all agree that each woman should have access to safe medical care if and when she needs it. Ensuring coverage for all pregnancy options ensures women's access to quality professional care without delay. AB 1295 aims to undo long-standing California law that protects women's health. The bill is a fundamental attack on a woman's ability to choose. If passed, this bill would further encourage unsafe, do-it-yourself termination of pregnancies. For these reasons, Planned Parenthood asks that you vote no on AB 1295.
Thank you. Further witnesses in opposition, name and organization position only, please.
Catherine Williams with American Civil Liberties Union of California, in strong opposition.
Shannon Smith Crowley, representing the American Congress of Obstetricians and Gynecologists in California. We oppose and we ask for your no vote.
Chair and members, Kathy Mossberg, representing the California Family Health Council, also in opposition.
Thank you. Seeing no further witnesses in opposition, questions or comments from the committee? Mr. Chavez.
I have a question of the bill, maker of the bill. If I heard you right, you're making a constitutional legal argument, not a discussion of abortion. Is that correct?
It is. It is correct. I'm making a constitutional legal argument, and it was even supported by the opposition. If you look at the opposition's comments that they made about having a right to choose, they have a right to choose just like the faith community has a right to choose, regardless of what side of the issue that you are on, whether you support your pro-life or your pro-choice. Everybody's ideology under our Constitution shall be considered, and everybody's belief shall be considered. And you shouldn't deny one person's civil rights over another person's rights or another organization's rights just based on the fact of your personal opinion of an issue. That's what makes America great. So the argument before you is a violation of the Constitution and a violation of the federal Hyde-Weldon Amendment that jeopardizes a tremendous amount of money because the federal government says you shall not discriminate against a Pastor Jack Hibbs and their belief system in not funding abortion rights. This is a 40-year-old law that was just recently reinterpreted by one individual that's unelected. So this law has been, if she's reinterpreting this law just recently over last summer, then it's been wrongly reinterpreted for the last 40 years. But I submit to you that it's been rightly interpreted, and if the legislative body choose to change this and make abortions an essential service, then pass that law. Don't let unelected bureaucrats that aren't accountable to the people that we represent make decisions for us when the intent of the law has been in place for 40 years.
Yeah, that's what I thought it was. It was a legal discussion. My question then is, why are you before a health committee, not judish? Why is it here?
I'm sure this bill will be doubly referred if it gets out of this committee.
Okay, thank you. Move the bill.
Thank you. Thank you.
Ms. Waldron.
Thank you, Mr. Chair. Just two questions for clarification, and then I'll have a comment. So California exempts certain religious employers from requirements to include contraception.
Yes.
But this exemption does not exist for abortion.
Yes.
So that's kind of a...
That is correct.
Yeah, that's kind of a weird twist there. And then you had mentioned that California could lose tens of billions in federal health care dollars because of this violation. Can you expand on that a little bit?
So, yeah, absolutely. I'll have this attorney, I'll have Mr. Mattox respond. He's an attorney from Washington, D.C.
So the Weldon Amendment, which is the key piece of law that's at issue here and was not even mentioned by the opposition and has never been explained by DMHC or even in your packet that you received. That's the key piece of information here. It's been in effect for 10 years, or 9 years, I think. It's a federal law that says if you receive funds, states that receive funds under the Weldon Amendment are prohibited from discriminating against an insurance plan that does not include abortion coverage. What DMHC did was to say, we're not going to allow insurance plans to exist that don't include insurance, that don't include abortion coverage. That's clear discrimination in violation of the Weldon Amendment. We have complaints pending in the HHS Office of Civil Rights in San Francisco looking into DMHC here. And what that highlights is that you have a bureaucrat in DMHC who's made a decision that potentially could take away billions of dollars from California programs, and is not even explaining how they're even how they even think this possibly complies with the Weldon Amendment. That's a decision that should not be left up to an agency like that. If someone is going to make such a decision and challenge the federal government in that way, that should at least be made with the signature of the governor on it and with action from the legislature.
May we have time to respond?
Well, typically how the rules of the committee work is if you're asked a question, so anyone up here at the committee is free to ask you a question during the course of their comments. So I think Ms. Waldron at this time is directing the question that way. If you'd like to, Ms. Waldron, if you'd like them to respond, you may ask. If anyone else on the committee would, when it's their turn, they can ask too.
Well, I could hear your response, and I probably have other questions, so.
Are you?
If you'd like to respond.
Thank you very much.
There are several issues. The first issue was
their argument that this is discriminating against religious entities. The Knox-Keene Act only governs insurance plans, and those are the only plans that the DMHC regulates, and no insurance plans have complained about this. This does not touch religious entities at all, number one. Number two, they continually refer to the Weldon Amendment, which is a federal amendment. Only the federal government can enforce the Weldon Amendment, and it has never been enforced by either Republican or Democratic administrations. Number one. Number two, it's not directed at secular commercial entities. It's only directed at religious entities. And as I just mentioned, no secular commercial entity, which is what's governed by both DMHC and the Knox-Keene Act, have objected. And number three, California regulators are not discriminating against insurance companies by enforcing Knox-Keene. Religious entities have many options for getting insurance. They can self-insure, and they can get plans that are regulated by other entities, not simply DMHC. So they have other options available to them. This is not discriminating against them. What it's saying is, if an insurance plan wants to offer a plan that's regulated by the Knox-Keene Act, it cannot discriminate and exclude abortion.
Mr. Chair, I'm sorry.
Well,
permission to respond to the 3 inaccurate statements that were just provided.
Ms. Grove, let's conclude with her comments and try to keep this in order. I would remind everyone on the committee, all my colleagues on the committee, we have 32 items today. So everyone should get their questions answered and we should proceed. But I just want to remind that in order to proceed in an orderly fashion, let's stick with the rules of the committee that apply to everyone. Ms. Waldron, you may complete your questions. And if anyone else wants to speak, Ms. Grove, you'll have time to close, and in your close, I think that's the appropriate place for you to address those concerns.
Thank you.
Ms. Waldron.
Okay, and I appreciate, because it's, we want to get everything out in the open. So if you could respond to those in your close is fine. Because the people who are being discriminated against, what I see, are the people of religious faith. So I just pulled the First Amendment to the U.S. Constitution. It seems to be being trumped by state law in the way we're doing things now, because the First Amendment clearly prohibits the making of any law respecting an establishment of religion or impeding the free exercise thereof. So clearly, the Constitution of the federal government should supersede the state. So I will be a yes vote on this. Thank you.
Thank you. Any further questions or comments from the committee? Seeing none, Ms. Grove, you may close.
So 3 inaccurate statements that were made by the opposition when she said, number one, that it doesn't affect religious organizations. You just heard from a pastor of a 10,000-member church from Calvary Chapel that shows you how it affects religious organizations. Number two, that this bill or this issue has not been challenged to the federal government. Bill Lockyer challenged on behalf of California this challenge to the federal government, and he lost. So it has been challenged and it has been brought forth. And number three, the expense, pardon me? Self-insurance, and addressing that there's other alternatives out there. It's required to have medical insurance under the Covered California and the Affordable Care Act. And so these churches or faith-based organizations have no place to go if they're going to take money that is tithed and given out of people's pockets to this organization, and then that money is going to be used to fund something that they truly believe is against the full authority of the Bible. It's just as much as an issue for Planned Parenthood or any other organization to have their freedom of right to associate or speech or to act, but as it is for Jack Hibbs and churches across the state to act. Whether you disagree or agree with the issue of life, that's not the issue before you. The issue is to allow them to have their separate associations and their separate freedom of belief without government interference. But this particular issue has government interference putting $40 billion in jeopardy with the state of California for plans that we cover for issues like health and welfare, CalFresh, all of those health and human services issues that the state so vitally protects. I would ask for an aye vote. Thank you. Sorry, and again, Mr. Chair, thank you for letting us go out of order.
Of course, happy to do so. Thank you, Assemblymember Grove. We have a motion. We have a second. The motion is due pass to appropriations. Madam Secretary, please call the roll.
Bonta?
No.
Bonta, no. Mainshine? Bonilla? Bonilla, no. Burke? No. Burke, no. Chavez? Aye. Chavez, aye. Chu? No. Chu, no. Gomez? Gonzalez? Hernandez? Lackey? Aye. Lackey, aye. Nazarian? Patterson? Patterson, aye. Ridley Thomas? No. Ridley Thomas, no. Rodriguez? No. Rodriguez, no. Santiago? Steinnorth? Aye. Steinnorth, aye. Thurmond? Waldron? Waldron, aye. Wood? No. Wood, no.
Assemblymember Grove, the count is 5-7. You need 5 more to get out. The bill will be on call.
Thank you. If the bill fails, permission for reconsideration?
Of course.
Thank you.